Well, greetings again. Today we're going to take a look at a lesson where we're going to talk about the following items. We want to talk about the citation, the complaint, the summons, the warrant, subpoenas, a parking ticket, and due process of law. I'm going to start in the reverse order, but this is called service of process, or it's the service or the due process that you're entitled to as you begin the case. And I've picked a corker of a case. Let me give you a little background on the case that I'm going to show you. It's a case that involved me in what was a felony and then later reduced to a misdemeanor. This case is this big. I think there's 35 motions in this case. It illustrates a particular fact that when I play the game, I play to win. And the game, if you're going to play, you have to play to win, or you're going to find yourself in a lot of trouble when you have 5, 6, 8, 10 convictions against you and they're not appealed or the convictions have been upheld. I was just in a sentencing hearing this morning before I came into the studio to shoot this particular segment. And the prosecutor came in and he said, "This Gordon's got a rap sheet as long as my arm." And there was one interesting comment that the judge made as she was reading through it. "But Mr. Prosecutor, there aren't any convictions." And that's right. Boy, I've got a lot of arrests and I've got a lot of tickets, but there are no convictions. And the reason that there are no convictions is because each and every one of those cases was treated just like it was murder one. And that's what each and every one of us has to do when we go into the courtroom. You can't go in and say, "Well, I'm busy this week and I'm working on my farm or I'm doing this or that," and then let these cases slide. You're better off to go get the driver's license, or you're better off to act the part of a slave and live that way than you are to try to act free when in fact you are a slave and then get a bunch of convictions against you, because later on they'll use those convictions and say, well, as the prosecutor did this morning, Mr. Gordon has no respect for the law whatsoever. Well, I talked for about 30 minutes this morning and I covered that aspect of whether or not I respect the law, and my argument is, or my position is, that I respect the law, and I'm able to quote, and this morning I quoted 17 Supreme Court citations out of this book called Legal Quotations. And I'm going to start here in legal quotations in this lesson, but to illustrate the fact, prosecutors will oftentimes, along with policemen, become vindictive. They have an evil motive bent on malice, and their objective isn't truth and honesty and righteousness. It's, we don't like you and we're going to put you in jail and we're going to make you obey these statutes and laws. They really, in fact, are little petty tyrants and little petty Hitlers. Now, let me give you a little background in this particular case because it was a little funny. I was arrested originally for no driver's license, registration, and proof of insurance, which in the state of Idaho is a violation of our own state statutes under Idaho Code 49-1109 through 1120. Wherein in the traffic codes, the only thing that you can arrest a man for are 5 or 6 particular items, and one of them is hit and run and felony manslaughter and drunk driving and driving under the influence of drugs, etc. And those are some cases where the police officer has the power to arrest. But the driver's license statute, registration, proof of insurance, running a stop sign are not the type of infractions or misdemeanors that can land you in jail. So they grabbed me and they hauled me off to jail. And then while I'm in jail, they wanted to take these fingerprints. Now I want you to take a look at this fingerprint card, because the fingerprint issue is a pretty important issue. And I want you to notice that I got my fingerprints back. And these fingerprints that you're looking at here are not the fingerprints that they took on this particular day, because they didn't get any fingerprints on April the 8th or on March the 24th, because I wouldn't give them to them. And when I went into court and got my fingerprints ordered returned under the statutes here in Idaho, they didn't have anything to return, so they sent these back. And the truth of the matter is, let's see, failure to register, failure to exhibit driver's license upon demand, and destruction of jail property. Now, they crossed out destruction of jail property. There's no signature on here because I don't sign admissions and confessions, and the fingerprints are smudged. No, that's too bad. I don't take good prints, I guess. Now, that's the last item I've got. Maybe a little off point, but I think I want to illustrate that point for you because remember I said that pursuant to Davis versus Mississippi, you don't have to give those fingerprints without a court order. And so here I am, I'm arrested for the big three, and while I'm in there, some mysterious thing occurred. And you have to always be prepared for this because you may be framed. You may be set up and entrapped. All I know is that they wanted me to wear this orange jail suit, and I objected to wearing the orange jail suit, and I took it off. Sometime during the middle of the night, something mysterious occurred to the orange jail suit, and the next morning it was in 11 pieces. Now, it wasn't ripped. That is that the fabric wasn't ripped, but all the thread just disappeared. And we don't know whether it's the same jail suit that was issued to me or not, because all we know is all the facts and the evidence showed was that under my bed was this little pile of rags. And this police officer came in, and he just come unglued, and he jumped up and down, and he pawed the ground and bit the bushes and chewed, and he huffed and he puffed, and he grabbed me and he pushed me up against the wall, and I won't repeat what he said because it was nasty. And he said, "You're under arrest for destruction of jails, and that's a felony." Oh, I'm telling you, he was like Hitler at Munich. He was just jumping up and down. He was shaking. You know, he was so mad. To which I replied, "Let me ask you a question here, sir. At this juncture of time, am I in an in-custody interrogation, and should I now demand counsel? And, of course, may I invoke my Fifth Amendment rights to remain silent?" And when I did that, he just, if you think he was unglued, when he was yelling at me to start with, he just come further unglued and get on down the hall. And we went down the hall, and they wanted to book me and mug me and print me. I guess they didn't know who I was or something. I don't know. Every time they have a new crime, they want fingerprints for every crime, every alleged and pretended crime. The only thing they're not doing now is shipping us off to London for trial. That comes a little later, I guess. So they charged me with a felony, destruction of jails. And I'm here, I am just sitting in the jail there in my underwear, wondering what's the matter with this guy. The ultimate end of the case was that it was brought as a felony, and then it was dropped as a felony, and then recharged as a misdemeanor. And then from a misdemeanor, I went into the court and I argued pursuant to one of our statutes, which is Idaho Code 193506, that a misdemeanor cannot be brought twice on the same facts, so therefore the intent of the legislature was obvious that if a felony is brought, it can be brought again. In other words, you can be charged with murder 1, and then it can be reduced and rebrought as murder 2, and then dropped and rebrought as manslaughter, and then dropped and rebrought as aggravated assault, and that's all right. But when you bring a misdemeanor, destruction of property, malicious injury to property, if you bring that once and drop it, you can't do that again. So therefore, common sense told me that if you bring it as a felony and then drop it as a misdemeanor, then what you've got is the equivalent of 2 misdemeanors. And so the judge saw it my way, and he dismissed. So I'm not going to send this entire case with each and every one of these lessons because I think that's superfluous, and many of the motions that you see in here you're going to have from other lessons. And keeping in mind that the number of motions that you file is not really relevant to each and every case. We have a student here who's working on a stop sign violation. Somebody said that he didn't stop at a stop sign somewhere, and I don't know whether he did or not, and he didn't say. All I know is that he's filed 64 pieces of paper with the court, and they said something like they wished he'd plead guilty and pay him the $16. And so far they've paid $500 or $600, and the last I heard he's going to trial here in a week or two, and it'll cost him another $1,000, and then they'll have $1,500 or $2,000 invested in the $16 ticket. And they're doing this with the intention of, well, we'll punish him, see, we'll make him defend himself. And that's part of their objective, is to make you defend yourself, and it'll cost you a lot of money and take you off your job, and you'll give up and quit, and then you'll just go in like a good sheep and you'll be shorn and pay your fines. Well, those of us around here in Boise are a little different breed of cat than the average, I guess, that they've been trying to breed around here, because to my knowledge there isn't a single parking ticket or a single stop sign or any other charge, to my knowledge, that our students, our graduates, haven't challenged. We estimate that it's costing them about $3 million a year now in Idaho at this juncture of time, and we hope to raise that to $6 or $9 million a year. And there comes a point in time when the law of diminishing returns comes into force and effect, and then they're going to stop prosecuting people for these pretended crimes. Now, I said that I wanted to start with the bottom order, which is called due process of law. So I want you to take out legal quotations, and I want you to follow along with me. I'm going to read a few of these to you. This book is a real gold mine, and I want to show you as we go through, and many a time I'll take these, and of course our briefs and motions have hundreds and hundreds of these nifty little quotations from our Supreme Court. And as I've noted in court this morning, I cited the Supreme Court 11 times with citations to substantiate my position, and the prosecuting attorney never cited one Supreme Court case, not even a state Supreme Court case. He didn't even cite a circuit court case. And so my observation is that our adversaries don't know, nor do they understand the law. Hence the famous little quotation, "You do err, sir, not understanding the law." Let's start off on page 20. I want to read one of the keenest, most succinct statements of a free man's status and his ability to contract and his ability to use the Constitution in contradistinction to a corporation that you're ever going to read. And this is called Hale versus Hinkle, and it's cited at 201 U.S. 43, and this particular citation comes from page 74. And you're going to find it on page 20, and it's number 48. So take out legal quotations. That's the green book, and it's got probably 300 quotations from the Supreme Court and various other authorities. And on page number 20, number 48, read along with me. "We are of the opinion that there is a clear distinction in this particular between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for an examination at the suit of the state." Well, we agree wholeheartedly, and it isn't that we agree because we're superior scholars to the Supreme Court. As a matter of real practical fact, as I tell my students, I hadn't known the law until the Supreme Court had instructed me. My instruction came from the Supreme Court, and so therefore I tell my students, you don't believe anything that George Gordon tells you. What you believe is what you see here on page 20. And if you think maybe this is a lie, then why don't you go to your law library and check it out and make sure that it's the opinion of the court in this particular case. And I had a judge the other day tell me, in this particular trial I was telling you about, I cited Georgia versus Brailsford in 1797, that the jury has a right to try the law as well as the facts. And the prosecutor jumped up like a little bandy rooster, and he just ranted and raved on for about 5 minutes about how this is old law and it can't be applicable and we can't allow the jury to try the law as well as the facts. And so I just kind of sat there and got all finished. And the argument to that is, well, if I might observe that the Supreme Court of the United States, when it makes a decision, usually cites some citations from earlier cases. And if it pleases the court, would you please take note that in Miranda versus Arizona, the Supreme Court cited the John Wilborn case in 1637, which was only 17 years after the Pilgrims landed at Plymouth Rock. It would appear to me that the Supreme Court of the United States thought that case some 300 years ago was worthy of comment in 1968. It would appear to me that a Supreme Court decision made a mere 200 years ago would have some veracity or weight. And in addition, if the court would like to entertain the idea that that case has been overturned, since this is an adversary circumstance, would the court please direct the prosecutor to cite the appropriate case that overturned Georgia versus Brailsford so that we can then know the truth of the matter? Well, of course, nobody wants to do any research. The courts at the lower level seem to be incompetent or incapable, and the prosecutors have come out of law school and they're not able or capable. And so, of course, it went to the jury and I was found guilty. But boy, I'm going to have a lot of fun as we run this through the appeals process. And Ada County, if they want to, can spend $60,000 trying to find out whether Georgia versus Brailsford's been overturned or not. I'll bet you $1 to donuts that when we get to Washington, the high court's going to snicker a little bit, because I don't think Georgia versus Brailsford's been overturned by our high court. So anyway, that's a little dialogue off into left field there a little bit, but always keep in mind that your adversaries will get off point from time to time, and they'll try to lead you off point, because the average guy, when he's brought up with this concept, well, that's an old law, see, that's 200 years ago. So that's right. Our legislature changes the law with every wind of doctrine, but the Constitution is a superior document, so says Marbury versus Madison, and it is not subject to the winds of change by the popular modes of the populace and the Congress from year to year. It's cast in concrete. The individual going on here then may stand upon his constitutional rights as a citizen, and I want you to notice the right citizen, not member, subject, slave, or corporation, but as a citizen he may stand on his constitutional rights, and he is entitled to carry on his private business in his own way. His power to contract is unlimited. Now, I don't know about yours, friend, but my power to contract is unlimited and is protected by Article 1, Section 10. He owes no duty to the state or to his neighbors to divulge his business. And I don't owe any duty to my state or to my neighbors, or to open his doors to an investigation so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom. I don't get anything from my state, so therefore I don't owe him anything. Beyond the protection of his life and property, and let me tell you, friends, the only legitimate function of government is to protect your life, liberty, and property, and that's the only thing that they don't do. They're so busy passing out food stamps and Social Security and other welfare programs and regulating automobiles on the road and protecting the claims window of insurance companies that they don't have any time to protect your life, liberty, and property. His rights are such as existed by the law of the land, antecedent to the organization of the state, and that law of the land is the Magna Carta, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. That's an interesting statement. I didn't have any warrant of the law issued before they took my automobile and my motorcycle and before they hauled me off to jail for not signing the state's contract. In other words, they seem to have the idea that they can pass a law and compel you to sign a contract. My right to contract is unlimited. You can't compel me to sign up with an insurance company to protect the roads or the people that use the roads, or for some alleged or pretended purpose, or cause me to get a driver's license or register my car. My right to contract is unlimited. He owes nothing to the public so long as he doesn't trespass upon their rights. So when I'm out driving on the road, as long as I don't run into somebody, run them off the road, or trespass upon their rights, I don't owe anything to the public. And that's not 1 Gordon 14:4, friends. That's Hale versus Hinkle. An individual may lawfully refuse to answer incriminating questions unless protected by an immunity statute. That's a pretty powerful little statement there by your federal Supreme Court, and I know I talk to people all the time that say they think that the Supreme Court is simply there to turn criminals loose and tread upon our rights. Why don't you go into court and cite Hale versus Hinkle? Because I noticed today that the court actually suspended the money damages. Well, that's the fine. You know, it's really a civil action in these traffic courts, and they were assessing some money damages because I didn't have insurance and I don't know, registration, I guess it was. And here's a judge, when I brought up the money issue today and argued it correctly pursuant to our state statute, that judge said, well, I'm going to suspend the money damages because of your money argument. And I'm going to go ahead and sentence you to 35 days in jail. To which I argued, well, wait a minute, you can't put me in jail for 35 days. That's a violation of Argersinger versus Hamlin, and you denied me counsel. So this entire proceeding is null and void. Ab initio. The automatic reversal rule comes in. Now going on with this thing called due process of law, let's read some definitions from our Supreme Court as we go along, and let's see what due process of law is. So turn with me right up here to the very beginning, page 12. Let's look at number 7 and 8. If you'll find it with me, page 12. Number 7, by the law of the land is more clearly intended the general law, a law which hears before it condemns, which proceeds upon inquiry and renders judgment only after trial. After trial we render judgment. Number 8, law in its regular course of administration through the courts of justice is due process. All right, now I want you to follow that one along. That's an important statement there. That's an old case. That's Leeper versus Texas, 139 U.S. 462, and I'd say 139 is back around Civil War days. So here around Civil War days, law in its regular course of administration. There is a regular course of administration. Now, let me tell you, friends, if you're in Idaho, the regular course of administration is something that you're not going to see here in the lower courts. I can't speak for the district court, and I can't speak for every district, but I haven't seen a magistrate court yet in Idaho that could give you what's called the regular course of administration through the courts of justice, and that's called due process. Number 11, due course of law. This phrase is synonymous with due process of law or law of the land, and law of the land comes from Magna Carta. So this thing of due process of law is older than the hills. It comes from about 1215 and means law in its regular course of administration through the courts of justice. And there's another citation, Kansas Pacific Railroad versus Dunmire, 19 Kansas 542. It's a pretty old case. I'm going to go on to number 12. Amendment 5 of the Constitution of the United States provides that no person shall be deprived of life, liberty, or property without due process of law. So here's your constitutional enactment. And if you're in Idaho, our Constitution says in Article 1, Section 3 that the federal Constitution is subservient to, our Constitution is subservient to the federal Constitution. Everything in the federal Constitution is thereby added to our state Constitution. Take a look in your state. It's probably the same. A similar provision exists in all of the state constitutions. Well, I'd go along with that. The phrases due course of law and the law of the land are sometimes used, but all three of these phrases have the same meaning. And that applies conformity with the ancient and customary laws of the English people or laws indicated by Parliament. That comes from 96 U.S. 97. That's a Civil War case or around that period of time. Looking at number 13, the adoption of the 14th Amendment completed the circle of protection against violations of the provisions of Magna Carta which guaranteed to the citizen his life, liberty, and property. Against interference except by the law of the land, which phrase was coupled in the petition of right with due process of law. The latter phrase was then used for the first time, but the two are generally treated as meaning the same. This security is provided as against the United States by the 14th and the 5th Amendments and against the states by the 14th Amendment. David versus New Orleans, back around Civil War years again. Now I could go on and on. I'm going to stop there because I want to get into other subject matter here, but I want to show you how to use this index. If you look here on page 2 of this appendix, you'll find the subject matter identified here under due process of law, and there must be 25 or 30 major federal citations along with some state citations and some other books. And there you have the subject of due process of law. When you go into the courtroom, when you have an opportunity, you always want to cite the quotations that are applicable from the Supreme Court of the United States. Don't Mickey Mouse around and cite Fourth Judicial District rules or rules of procedure. Just go right to the horse's mouth. If they argue, well, that's old, that's around Civil War years. Remember Miranda. They went back to the John Wilborn case and a dozen other citations that were 100 to 200 years old. pursuant to this Fifth Amendment thing. And don't ever forget that the Supreme Court rarely changes law. As a matter of fact, their sole purpose is to set the statute next to the Constitution and make the determination as to whether the statute violates the Constitution or the rights of this individual in this case. And it's decided on a case-by-case basis. And it isn't always applicable to go to a particular case and say, well, this case was decided this way, so therefore my case should be decided this way, because your case will have different facts. You use those Supreme Court decisions as guidelines. But let me tell you, it's the law of the land. And when you're talking about counsel, which in Idaho, you know, is like falling off a greased banana peel on a log in the middle of the Colorado Rapids. You can't get counsel of your choice here in Idaho, and I want to lay this one on you here. There's some real funny ones in here. Turn to number 214 on page 62. I don't know about your state, but we have a pretty strong union here in our bar association, and they absolutely refuse to let lay counsel come into the courtroom. Look at number 214. Lack of counsel of choice can be conceivably even worse than no counsel at all, or of having to accept counsel beholden to one's adversary. That's the one you want to cite every time. Your Honor, I don't want that lawyer back there that you've appointed for me, and I don't want any lawyers that are members of the bar. That would make me beholden to my adversary. I don't want counsel of the court's choice. I want counsel of my choice. And the Supreme Court of the United States in Burgett versus Texas, 389 U.S. 109, tells me I have that right. Now, when they deny you that counsel, don't sit there and cry and wonder, oh my, you know, how can I move forward in this trial when I don't have counsel? Just sit there and do the best you can with what you've got. Turn over here to page 60 with me and look at this quotation and see how these apply. And I use them in the courtroom. I'll quote citations from the Supreme Court 10 to 1. My adversaries very seldom can ever quote anything because they don't know anything. The right to counsel in number 203 on page 60 at a criminal trial is deemed so fundamental to the interests of justice that denial thereof automatically vitiates any conviction obtained. Let the judge know that. Put them on notice. Get that in the record. Read that into the record and tell them that that's the automatic reversal rule. This is true, Your Honor, even though there is no showing of any prejudice or unfairness in the proceedings or even any need for having counsel. Friend, you can go into the traffic court. You don't even have to show you needed the counsel. You just have to make the demand timely. Your Honor, let the record show that I'm appearing here today without counsel and without counsel of my choice. I demand counsel and counsel of my choice and time with which to select said counsel. Don't use the word attorney and don't use the word represent. You're not entitled to representation by lay counsel. You're entitled to your next friend. And our motions and briefs on the subject of counsel will more clearly explain that to you, and you should have a lot of these motions and briefs, and as we go through the course, you'll have an opportunity to order them from us, or you'll get them as part of your lesson material. But I'm not going to sit here and read all of these citations to you either, but I did this now to illustrate the fact that the Supreme Court of the United States will rule in the favor of an individual 9 times out of 10. And that includes the individuals who are guilty of crimes and unable to make an articulate or intelligent response or petition to the court. Because it's their purpose, it's their duty to protect rights secured by the Constitution. And where rights secured by the Constitution are involved, there can be no rulemaking or legislation that would abrogate them. From Miranda, page 491. So there's the subject matter of due process of law. And due process of law, then, is the orderly, systematic process from day one through conviction. And when the court, or the prosecutor, or the jailers, or anyone else refuses or fails in some way to give you due process of law, note those down each and every time. And so, here's your file folder, and originally it started with the folder only. And the first thing you do then is when these violations come up, for instance, you go into arraignment and you demand all of your rights. and they bring you into a motion hearing, and you bring up the subject of counsel. And they say, if he's a licensed lawyer, he's all right, but if he's not a licensed lawyer, then no way. That's the answer that you wanted. It wasn't that you needed counsel, you just needed him to tell you you couldn't have it, because that's the winning argument. Now you file the notice and demand for counsel and the brief in support thereof. And there becomes an appealable issue, because here's your Supreme Court, and I just read 2 or 3 of them to you, that says it doesn't even make any difference if there was no prejudice and no need for counsel. The fact that you denied it and he said no invokes the automatic reversal rule. I don't care how the jury rules. It's not relevant to me. All I care about is being able to go into that court and have that judge say no counsel. And then the issue isn't, well, did you destroy those jail clothes or not, or did you destroy a jail? That's no longer the issue. It's why did you deny George Gordon due process of law under the 14th Amendment as it was guaranteed under the 6th Amendment in his right to counsel, and thereby violate his 5th Amendment right to due process in the process. And there's 3 constitutional amendments violated by a judge who's doing nothing more than protecting the monopoly of the Idaho State Bar Association in their hammerlock on our court. I don't care if they have a union monopoly in the courts. I have rights, and my rights supersede their monopoly. You can't get a conviction against George Gordon in the state of Idaho. And if you do, it'll be overturned up the road when the Supreme Court sees it. And then I come into the court, and this little flat-chested twit comes in there and says to me, "This guy is obstructing and delaying justice, Your Honor. Why, he has no respect for the law." I like that kind of foolishness because it guarantees me victory. Now I want to show you something here, and this I'm going to include in this packet. There's 3 yellow pages. Zoom in on these, would you, Ted? I want to show you what this is and what it's all about. Notice up at the top of the page it says 25C 2578. And you'll notice number 1, it says letter of invitation to arraignment, 8/11/70 or 82. 8/11/82. Okay? Now, pick these up and let's follow along, because I want to run through here and I want to show you what it is in the way of paperwork and how you're going to assimilate this paperwork in this file folder. I'm doing about 13 cases right now. I think they've charged me with 5 or 6 more criminal matters, and I'm doing 3 or 4 or 5 or 6, I've lost track, of the civil matters. And in addition to that, I'm preparing 4 more Title 42 suits. Handled correctly, you can do a number of cases at the same time. Remember that the average lawyer probably does, 25, 30 cases at a time. He's probably got 25 or 30 customers or clients, that come into him, and over the course of a week, and of course these cases drag on for 4 or 5 months, you can do 10 or 15 at a time. But you've got to have them organized. Could you imagine doing 3 cases with this much paper? Look at that. All that paper in there, and you've got this case number with that case number, and they're out of sequence, and the filing stamps are all different. Friend, you can't function like that. And most of the pro ses that come into contact with us here at the school will come in here after they've gotten, 4 or 5 pieces of paper, and it's folded about 3 times, and they reach up here. Yeah, here's the complaint, and there was some other papers, and I don't know what happened to the other papers, but I've got them around someplace. I don't know if that guy needs legal assistance. I think what he needs is a priest to administer the last rites, because that's not a serious pro se. That's a fool that comes into the school here and he says, well, I'm lost and I don't know what to do next, and I want you to help me and I want you to solve my problem, and I want to just buy a fish from you, and I don't want to learn how to fish. I just want you to do it for me. And that's the good old American way. You go to that government school, you come out of the government school, and what do they tell you? Well, let's see, you're a trained functionary. You're a trained computer programmer. That's all you can do. You're a total illiterate and a dysfunctionate in the rest of society. You can't do anything but that. All right. So as you read along here, I want you to read with me. This is in longhand. I didn't type this out. Because what I do, the moment I get a letter, and this was the first letter that I received, zoom in on this one, and I'll show you how I put this together. And I'm not telling you that you have to have any particular order or methodology. That's not relevant. You organize your file folders in whatever way you want to do it. But I'm going to show you how I do it, and I would suggest that you organize your file folder the way I do to start, and then when you can improve on it, do it that way. The first thing that happens is you're going to get some kind of a letter from the prosecutor or someone, and it's going to be a summons or a complaint or an indictment or whatever it is. It's number one, number uno. And you put it in here, and I put down letter of invitation to arraignment 8/11/82, and it's number one. And there it is in my file folder, and up on that letter you'll see the number one circled. Then I've got 1A, 1B, 1C, 1D, and 1E. And here's what happened there. The next thing I got was a complaint dated 8/9/82, motion and order for dismissal, case number 10960, a summons, 25C 2578, dated 9/7/82, complaint dated 8/9/82, and a letter from L. Allen Smith bowing out. In other words, here we've got a judge who for some reason disqualified himself from the case. I don't remember disqualifying himself, but let me see what he said here. As you will recall, this matter was taken into advisement for the court to review the administrative order and directive. Upon a review of the administrative order, this case should be brought back before Judge Willis, since he originally had the preliminary hearing on these charges. I have therefore changed the date from Tuesday, September 28th to Monday, September 27th, before Judge Willis for further proceedings. Mr. Gordon should appear on Monday, September 27th at 2:30 p.m. Sincerely, L. Allen Smith, Magistrate. Okay? What he's saying here is that they brought this case originally as a felony. We had a preliminary hearing in front of Judge Willis, and Judge Willis bound this case over to the district court as a felony, and it went before Judge W.E. Smith. W.E. Smith handled the case for 2 or 3 months, and by the time we got some motions into the court arguing our position at law and our status and our demand for counsel and our demand for a common law jury and our demand for an indictment by a grand jury and an indictment in place of the information, and challenge the capacity of the prosecuting attorney because he's not a public prosecutor, and challenge the court because the action is brought in the name of the state of Idaho instead of in the name of the people of the state of Idaho against George Gordon, and so on. These were my administrative procedural matters and my theory of the case and my demand for rights. That sounds like a mouthful. Now, it really isn't, because all of the motions and briefs that we have ever put out are available to each and every one of you as computer subscribers for 15 cents a page in the original ready to file. All right? So now, let's take a look at what happens next. Remember now, the first thing that happened to me, and if you're following along here in our course outline, I went through due process of law here, and now the first thing that happens then is you get a citation, or you get a complaint. You get something from the court. In this case, the citation is an indictment. It's an information is what it is. It's not an indictment. Let me run over that. You get a summons, an information, or an indictment. And if it's a petty misdemeanor or a petite crime, you can get just a traffic ticket from the policeman. And in the process of what's called due process, you have to be served with this type of a complaint. And then depending upon your status, it'll depend upon whether or not that is adequate due process. Let me give you an illustration of that so you can understand. The policeman gives a traffic ticket to a licensed driver and summonses him into the traffic court. That is due process of law, because the man has volunteered into a regulated enterprise. The OSHA inspector comes into the manufacturing plant and issues a citation to the corporate structure. That is due process of law, because that's a regulated enterprise. The OSHA inspector comes into your garage and issues you a citation because you don't have a guard on your saw in your own home, in your own garage. That is not due process of law. The guy's out to lunch. You see the difference? I don't have a driver's license, so the traffic cop can't give me a traffic ticket because that's not due process of law. I demand a sworn affidavit attached to a formal complaint pursuant to Rule 4. Now, that's due process.